Not no. Excuse me, that's not correct. It's going to be a hearing on my motion to dismiss the charging document and to change venue un, under Rule 1.801. Yeah, I'm more concerned not about the half day trial and all that. That stuff takes care of itself quite naturally. What I'm concerned about is not having enough time for evidence and witnesses for my 1.801 change of venue claims. I'm not talking. I'm not talking about the trial, the actual trial day, how long the trial lasts. What I'm talking about is when the trial is set from right now today to when it's set. There there is evidence and witnesses that have to be uh, acquired in order to make my defense. And well, but here's one other thing, Miss Meredith, that you need to know. Under the rules of civil procedure at 3237, lawyers as a witness, a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. And you know now today and other times how important you are to to be a witness. And you no 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 you're not. No, you're not. You're not. Timothy Meals is not. Joseph Naring is not. You cannot serve as an advocate for Heather Rouse in this case. You are a witness. You will be a witness. This is unbelievable. This is unbelievable. Kelly, I hope this is recorded, and I'd like the record to show that I just cited Rule 3237 to to the to Miss Meredith, who knows that she's going to be called as a witness, and she's proceeding to try and hurry this trial up as fast as it can, so that we just hear the contempt part, which is easy to prove, which takes about 5 minutes. Right. Well, we Tiffany and I were both in court. We both know that it would take about 2 minutes to prove the fraud of the charging document, but that the reason that we continued the case was because Judge Moore wanted me to address the Rule 1.801 change of venue claims. Because my claims are not even against my wife. They're literally against Tiffany and Timothy Meals and Joseph Naring and some other people, as I pled today who my witnesses are. I pled who my witnesses are. And there's absolutely no way under the rules of civil procedure, the model rules of professional conduct, that Tiffany Meredith can even go forward from this point right now. What she's trying to do is she's trying to protect herself not my wife, not anybody else. She's trying to protect herself from claims of official misconduct and professional misconduct causing intentional injury. That's what's going to be tried. No, I'm thinking more like June, because I have an appeal. I have an appeal Tiffany. I have an appeal right now. You're just simply trying to take advantage of Kelly and trying to move this as fast as it can go. So we just hear contempt, and I don't have enough time to prosecute basically you and Tim and everyone else. That's all you're doing, Tiffany. And you can't even be a lawyer under 3237. How about April 11th? I might be able to do all the ridiculous stuff I have to do between now and then. I don't even have access to evidence in my own case. You so, April 11th. Well, how about April? Mine is the first part of April. Whatever you can do, because this is going to be changed, and Tiffany's not going to be the lawyer anyway. I mean, it's impossible for her to be the attorney, and it's impossible for her to be scheduling really quick times. Because what she's trying to do is she's trying to schedule it real fast so that she doesn't get in trouble. So she protects her job, and she protects her reputation, and she protects her law license. All right. All right. I appreciate Kelly. I know you're a straight shooter, and I'm sorry to be so. I don't mean to be loud, but I'm just really scared and afraid. I've been wrongfully imprisoned 4 times already. For Kelly, is anyone still there? Wow. That I'm just like, you know, my my PTSD kicks in, and my PTSD kicks in whenever a lawyer or a judge. And I know Kelly's not a lawyer and Kelly's not a judge. And Kelly Orez has helped me a lot in the past, and but Tiffany got in there, and just let me. Here's what I wanted to do today was to continue this scheduling conference until I had my still. When anyone forfeits my rights to my face, or ignores the rules of civil procedure, or ignores the law, or ignores things, I go into a fight or flight response. I don't have any control over. And that's really all post traumatic stress disorder syndrome is. You know, if you're an attorney and you get raped of your rights to your face, get wrongfully tried, convicted, or imprisoned. You know, we used to say in stress and coping in psychology, and in studies of stress and coping and adversity, prevailing in the face of adversity. we would say that some of the most stressful things in life are the wrongful death of a child, a bankruptcy, divorce. But they all, I don't know about the child, but the worst thing that I've ever experienced, I think, is being wrongfully tried, wrongfully convicted, and wrongfully imprisoned. And then I'm kept in this district intentionally because they don't want me to get out of the district, because everything that they've done is already proven. It's already apparent, obvious, plain, and understood on the record. All the acts of official misconduct, all the acts of professional misconduct causing intentional injury, gross negligence, reckless disregard for the truth, malicious prosecution, Tiffany, not having candor with the court, not bringing merit claims of merit, and so anyway, here's what I wanted to do today before I was hijacked and jumped. And I'm so glad that I called. I am so glad that I called Kelly, because when I called her, she said, "Oh, I've got Tiffany on the line, and she said she didn't have your number." So they weren't even going to call me. They were just going to schedule it. And so I guess Judge Orr wrote an order and not Judge Moore for the scheduling conference, for whatever limitations they put on it or whatever. Judge Orr doesn't know anything about this case. And I don't want to go into that, but Judge Orr's done some. Judge Orr's been taken advantage of, and I have proof of that, and it's already on the record, already on the docket. But anyway, what I wanted to do was read this Rule 32.3.7, lawyer as a witness. This is a rule of professional conduct or professional misconduct, however you want to say it, misconduct or conduct. And the rule is a lawyer shall. That means must. It's an absolute imperative. A lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. So earlier today, I filed an emergency motion to continue trial scheduling conference pending further orders of the court regarding witnesses, evidence, and lifting blocks on evidence. It wasn't a long document. Here's some of the important things that a scheduler needs to know, Kelly Orez, and certainly Tiffany Meredith. Tiffany Meredith has a duty, has a professional duty, literally at Rule 32.3.7, lawyer as a witness, to take herself out of advocating for Heather. To remove herself from advocating for Heather. If she even has a general belief that she could be called as a witness. If she gets to a trial and she's called as a witness under the Sixth Amendment, right, there's nothing that trumps that. I suppose if you were doing it in bad faith, or it was somehow like fraud, or like some sort of sick, twisted lawyer trying to hurt another lawyer. I mean, my mind just can't even go there. But I mean, I suppose that's possible. But where I come from, or I'm from Iowa, but the way I'm educated in Arkansas is, if another lawyer even just says to you, "Hey, I'm thinking about this," um, you gotta walk away. You've got no skin in this game, do you, Tiffany? But when she's on the stand, she's going to be asked, you know, who are you protecting? State of Iowa government attorney. Who are you protecting when you prosecute an innocent man? You're protecting yourself. You're protecting yourself from anyone finding out about your acts of official misconduct, your breaches of professional duty, and professional misconduct causing intentional injury. You're protecting your job. You're protecting your reputation. You are you're protecting yourself at all costs. And so, after reading that rule, let's read it again here. Start talking too much. What I keep doing is I keep looking at the camera, and I can I made some of these videos so I can kind of recognize myself feeling like me again, finally, like normal, talking normal, and not getting too carried. I mean, I'm animated. I'm an animated guy. When I'm passionate about something, or convicted about something, or comfortable or confident in anything, I tend to be animated. But I'll have to go back and watch this film, and it's bothering me because it's hard to explain. What happens is cortisol. It's physical. It's not mental. It's not emotional. It's physical first. It's involuntary reaction. You have no control over it. And cortisol and adrenaline wash over your heart, wash over your brain, and you get in that sort of response, and it's like you feel like you're fighting for your life. You feel like you're fighting for your life. You're in a fight or flight response. But here's the thing that's weird about it. You're stuck on fight. And to me, that's not a comfortable feeling. It's very uncomfortable. So anyway, let's shake it off. Let's go back here to our Chapter 32 rule. A lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. So here's what we told the court earlier today after our Monday discussion, our Monday video, our Exhibit 5 video on the YouTube channel. I wrote paragraph 8. Government attorneys Tiffany Meredith, Timothy Meals, and Joseph Naring are necessary witnesses for just adjudication of Mr. Starr's affirmative defenses and claims of official misconduct and professional misconduct causing intentional injury. 11. Please see Exhibit 5, which was the actual video that we took on the YouTube channel. Please see Exhibit 5. 2024-12-16 Bill Watson call. Witnesses and evidence needed. Instruction for lifting admin blocks. Go to www.youtube.com/@TravisStar7948. Page 14. At the 18-minute mark, the subject of that Exhibit 5 video, At the 18-minute mark, the subject of blocked evidence violating my First, Sixth, and 14th Amendment rights, all at the same time, is brought up. And blocked evidence is destroying my ability to appeal in the JV order, which was termination of parental rights, at a trial I wasn't even at, and to gather file stamped evidence for myself. So I can't go into my own case and get my own documents back out for evidence. I can't open them. I can't look at them. I can't do anything. It's ridiculous. And it's intentional. It's intentional. It helps. It's done in my JV cases. It's done in my divorce, and it's done in my civil restraint. It's so that I can't appeal my horrific, unconstitutional parental rights case, and that I can't make my arguments for change of venue here. So change of venue, just generally so we know, if a judge has an interest in protecting himself from getting in trouble, that's a reason to change venue. And there's evidence for that for days, but I can't open it. The evidence that's blocked tends to be evidence that's incriminating of judges, incriminating of county attorneys, staff attorneys, incriminating of jailers, anything incriminating them of official misconduct or professional misconduct causing injury. Those are the things that are blocked, individually blocked. It's true. And I've informed the court of it. You saw in Exhibit 5 where I talked to Bill Watson about it. You saw in Exhibit 4 where I spoke to Shirley Faircloth about it. You saw in Exhibits 1, 2, and 3 where it was brought up in some way, shape, or form. The other reason to change venue is prejudice or influence. There's so many people that I have adverse claims against, 32 of them, that I can't possibly get a fair and impartial trial in here. And the other one is fraud in contract. And so the divorce, Heather filed the civil restraint intending to defraud the court, which she confessed to, for the purpose of taking further unconscionable advantage of me in the divorce with regard to property, which I have none. I mean, none. None. Not any of our 50-50 property, not even any of my property. Not my underwear, not my birth certificate, not my car title, not a pencil, nothing. So, so to take intending to defraud the court with the civil restraint application so that she could take further unconscionable advantage of me in the divorce with regard to custody of the children and property. And we entered into a fraudulent contract that was relied on in the parental termination trial hearing that I wasn't even at. That contract was born of duress, and the ancient Roman requirements for duress to avoid a contract, for undue influence, force, fear, coercion, duress, is historically just two things. One or the other, and in my case, I have both. You have to be in the custody of the state, which I was at the time of contracting, and whoever the other contracting party is has got to be withholding property from you, which she's done. And I filed something like, 10 motions for turnover of my property, and they're just ignored. The court just ignores me. The Nicole Fazio just ignores me. Everyone just ignores me. So those are the reasons for change of venue. So you can't just claim those things. You gotta have proof. And right now I have I do have 73 pieces of evidence on the dockets, but I can't open any of them. I can't use any of them. I can't show them to the ombudsman. I can't show them to the FBI. I can't open them. They can't go in and open them. And so these people think that they have me licked. They think, oh, he'll finally just quit now. He can see that there's nothing he can do. We've put him in a position, a wrongful position, wrongfully tried, wrongfully convicted, wrongfully imprisoned. And we've put him in this position. And now we're making him believe that he can't overcome. And that's what all of these acts of official misconduct and professional misconduct causing injury, like the Chapter 32, 3.7 rule that lawyers shall not advocate for anyone in a trial where they might be a witness. They just deny these things, and so that takes a lot of evidence, and I have it. I just can't use it, and that's intentional. So I said that we have blocked evidence, and it's destroying my ability to appeal in the JV order, parental rights order. Because see, when you appeal, you have to go into your docket, and you have to send the whole docket to the appellate court, and I can't do that. I mean, I just flat out can't do it. That is, not only is that an act of official misconduct, it's flat out it's obstruction of justice at this point, and it's felonious official misconduct, it's obstruction of justice, it's professional misconduct causing intentional injury, it's fraud. I mean, it's equivalent to fraud. So moving on. In the answer, Starr declares his need for evidence and material witnesses, including attorney Nicole Facio and attorneys Timothy Meals, Tiffany Meredith, and Joseph Naring. There we are again. I need you. Moving on. '27. Please pay special attention to Exhibit 7. 2024 4/24. Exhibit list in progress. And Exhibit 8. Witness list in progress. Paragraph 29. Tiffany Meredith, Timothy Meals, and Joseph Naring are in possession of these two documents, and they will do everything in their power and in abuse of their power and professional duties owed to prevent themselves from becoming witnesses. And that's what we saw today. '42. At the 21-minute to the 25-minute mark, Tiffany Meredith is needed as a witness. Starr shares claims against government workers. Starr needs evidence, witnesses, and is in desperate need to have the administrative blocks lifted. All right, 35 minutes to 43 minutes. Timothy Meals and Tiffany Meredith write the fraudulent charging document. Not Rouse. 35 minutes to 43 minutes. And again, this is of that other Exhibit 5 that you might watch on this channel. Tiffany Meredith is desperate to continue misusing and abusing Rouse's place and position as plaintiff so Tiffany Meredith can protect her job, her reputation, and her law license from suspension or permanent disbarment for acts of official misconduct and professional misconduct causing intentional injury. 50. 43 minutes to 53 minutes. Bill Watson and Starr determined that all of Starr's blocks began around 1/29/2024. That the documents that are blocked all tend to be incriminating of a government worker. Like the 73 pieces, those 73 smoking guns, those are the ones that are blocked. 53. 43-minute mark to 53-minute mark again. Starr and Watson are in agreement that the metadata of the commanding government computer can be discovered and identified. So whoever goes in and files cases, files things for me, maybe when I'm in jail, and they do something kind of ornery or improper, or the blocking of this evidence. We're in agreement that can be discovered. 54. 53 minutes to 59 minutes. Bill Watson gives Starr detailed instructions about what he, Starr, must do and how to go about doing it if he, Starr, wants relief from evidence blocks. So he told me what I needed to do, and I needed to file this, is what he said to do. So he told me, he's like, you need to, Bill Watson gives Starr detailed instructions about what he, Starr, must do and how to go about doing it if Starr wants relief from evidence blocks. 55. Bill Watson tells Starr in certain terms that he, Starr, must file an emergency motion with the court, tell the court what has been going on, and request the court to enter an order permitting Starr docket access in his own case as party and attorney as level 1. If you go back and you watch that Exhibit 5 of me and Bill talking, we didn't get, I didn't get, usually I want to know everything, but I just was like, he was telling me, do this, do this, do this, do this, do this, do this. And I'll get him on the stand one of these days, but it seemed to me that he has the power in his job to do these things. And a judge can or has in the past commanded him to do these things. And judges, of course, have the power to do them themselves. He made it seem as though that's just kind of the case. But once, if a judge has done something on his own or commanded Bill to do it, Bill will not, and this is kind of in line with what Tina Thomason said, they're not going to go fix it. They're not going to tell a judge he's doing anything wrong. And that's when we got to this whole thing, like when judges get really cantankerous in Iowa, you either got to go to the JQC, the Judicial Qualifications Commission, which I've done now twice, and they're really just not very helpful and slow and beleaguered. Or sue, sue civilly for official misconduct and professional misconduct. So level 1, from the 53-minute to the 59-minute mark, Starr reiterates Starr's evidentiary and witness needs and makes closing comments. 58. Without regular access to the dockets in all cases, it is impossible for Starr to predict the time needed for attaining evidence and witnesses. So I've got an appeal that I'm supposed to be doing. I've got this case to be preparing for on March 20th. And I'm not even able to make a crack at it. So it's impossible to predict the time needed for obtaining evidence and witnesses. 59. Starr is poor, indigent, living in the 6th Judicial District, and does not have access to docketed documents necessary for just adjudication or appeal or petition the court for invalidation of any order. I want to pick up on that, necessary for just adjudication. Witnesses are necessary when they're absolutely needed for just adjudication. So if I've claimed Tiffany Meredith committed this act of fraud. Tiffany Meredith, and not my wife, wrote this charging document. My wife did not call her attorney, Nicole Fascio. My wife did not call a cop out to the house. The 2 cops' names that we see on this document are false. They're just snippets taken from these people never went to these. My wife didn't call and complain about these necklaces. My wife already knew that I had the necklaces when I bought them, because I was talking to 178 oversight agents in the state of Iowa, and including her attorney, Nicole Fascio, including John Trillo, who works with her attorney, John Fascio, and is a father's rights attorney, and our sons are friends. And so she knew immediately on November 1st and November 2nd, when I first started opening up these documents and these videos to the people I was communicating to. Someone got a hold of her, and Heather was one of the very first ones in there, watching the movies, opening documents, because on Dropbox you can see them coming and going, and it says Heather Rouse, and Heather and I have other Dropbox accounts, and so she knew everything. So if you claim someone committed fraud, and you've got that piece of evidence showing the fraud, you're gonna want to ask them in front of God and everybody about the fraud, and you're gonna want to ask the other people who supposedly wrote it if they wrote it. It's not difficult. The same thing happened with Judge Ellison and Judge Drew. I think Ellison wrote the order, or the county attorney, Tim Meals, wrote the order, and they put down Judge Drew's name as writing the order. And it just annihilated my First, Sixth, and 14th Amendment rights, every rule of civil procedure there is, every rule of fairness, every rule of impartiality, the second canon of Rule 51, just obliterated it. And so one of 2 things is true. 3 things, actually. Judge Ellison wrote it and signed Drew's name without Drew's knowledge. 2, Judge Ellison wrote and signed the order with Judge Drew's knowledge. 3, Judge Drew wrote and signed the order and broke every rule there is. Ellison wrote the order and broke every rule there is, or Judge Drew wrote the order and broke every rule there is. That's it. That's it. So you call him up, put him on the stand and say, who's more terrible? You know, I mean, pretty simple, pretty straightforward. And the same thing would happen with charging documents and everything else. I have a few aces up my sleeve in this regard. So, all right, so I asked for an order that would direct all judges, court administration, and county attorney staff to cease and desist changing Mr. Starr's docket permissions in his cases. Order that Starr be placed in a position of utmost docket permission at Code Level 1, if that indeed be the correct information received from Bill Watson. So that's what I did. Order that once it is confirmed by Starr that the mere appearances of fairness and impartiality have been restored, and Starr has full access to the dockets restored, the Story County Clerk of Court be ordered to receive evidentiary request from Starr by email. Free of charge, of course. Further ordering that Starr's Sixth Amendment Second Judicial District employee witness list consists of the following as of December 19th, 2024. Tiffany Meredith, Tiffany Meals, Joseph Naring, Corey Davis, Lisa Heddens, Joel Navratil, Adam Packer, Clark Blue, Mike Dalbeck, Janet Baldus, Nancy Denicus, Tina Thomason, Bill Watson, Scott Hand, Shirley Faircloth, Kelly Orez, who we just talked to, and James Ellison, James Drew, and Adria Kester be. Those are my government witnesses. Those are it's not all of them. You know, when I come back later on and I sue people, it'll be much more than this, but this is just good enough. This is good enough for now. I mean, this is good enough to establish, you know, foundation for those 73 documents I was telling you about. Further order that Starr's Sixth Amendment private person witness list consists of the following: Tony Starr, Theodore Hall, Tessica Dooley, Nicole Fazio, Heather Rouse, Linda Miller, and Madison Starr. Further order that the County Clerk of Court be ordered to supply Starr with subpoena forms, which Starr will fill out, and the court, by and through the clerk, shall mail out via U.S. mail or via electronic mail to the intended witnesses free of charge. So I'm indigent, I'm proceeding in form of phosphorus, I have a Sixth Amendment right to compel witnesses, I have a Sixth Amendment right to compel evidence. And once the lights get turned back on or all these blocks are lifted, then I could call up the email the clerk, Janet Baldus, like I used to do in the past, and say, Janet, I need this titled Exhibit 1. I need 5 of these. I need one for the court. I need one for the court reporter. I need one for myself. I need one for the witness. And I need one for whoever the attorney is. And so that's kind of, you know, what my thought was. Further ordering that the scheduling conference ordered for December 19th, 2024 is canceled and continued pending further orders of the court, which shall address the evidence, blocking evidence, and witness topics in paragraphs 1 through 7 above. And so that's pretty much straightforward. I mean, it's not fancy law. It's not, I mean, you can clearly see where I'm establishing myself as a truth yielder. I find the truth, I identify the truth, and I just yield it. I yield to it and play it where it lies. It is what it is. These people are going so far out of their way to control the truth and control the narrative and protect their jobs. As we saw at Rule 1.801, the prejudice and influence, which is basically another way to say unfairness and discrimination or partiality, um, is steep, is very much. So anyway, so I don't know what we got to do. I guess there's a judge. They said Judge Voss Orr wrote this order, and I'm thinking, oh heck, Josh. I don't know if Judge Voss Orr is a district judge yet. I don't know. I think she works over across town in Ames. It might be a magistrate. I'm not 100% sure, but she doesn't know anything about this case. Why wouldn't Judge Moore write the order? I don't. I bet you 10-1. Timothy Mills wrote this order, put Voss Orr's name on it, and nobody knows. Moore doesn't know. Moore doesn't know. Orr doesn't know, and the county attorney is just living on borrowed time at this point. But it's pretty disgusting, you know. They said, "Oh well, we got an order, and the order says contempt. The order says contempt. It's just this contempt charge." Well, Nicole or Tiffany Meredith is an attorney, right? So she's got to have candor with the court, and she has to have candor with Kelly Orez, the scheduler. Tiffany Meredith knows why the trial was continued. The contempt charge could have been determined in 2 minutes. There's no there. It's impossible to charge. And we continued it because Judge Moore was like, she seemed like she was kind of concerned about the change of venue stuff and all the official misconduct claims that I had made. And she's like, if you want to handle all these things as well, it might take a little bit longer. And, and certainly here, when you see these witnesses that I've named, the government worker group, which is pretty big, and the private group, which is, kind of small, but I mean, it's big. It's a lot. It's a lot of evidence to go through, and by the time you have breaks, and by the time you have direct and cross and all that, and Meredith, well, like I said, she cannot possibly be the attorney. I mean, that just boggles my mind. I mean, that's like an automatic law suspension, and so that's why I think Judge Orr or Judge Moore, no judge knows what the hell's going on right now, to me. This is all the county attorney writing these orders and scheduling these things and telling Kelly Orez what to do. I've never seen anything like it. Not in a million years, would I think. And I think that's what triggered it. My PTSD at the beginning of this was when she fought back and says, I am representing them, and I will be representing them, and I will be at the trial, and I will try to schedule this as fast as humanly possible, and I will prevent you. I will prevent you from telling anybody the truth. If I have to block documents, I'll block documents. If I have to pump you full of insulin when you're in jail, if I have to not protect your First, Sixth, or 14th Amendment rights, I'll run right over you. There's so many people now in this district that stand to probably lose, that do stand to lose a lot. They're bowed up, and they're doing some pretty sick stuff. And the thing I don't like is, like, I'm a Christian, and forgiveness is an important thing in my life. And it's like I don't get any opportunities here in Iowa. There's nobody lamenting, confessing, repenting, and then coming to me for forgiveness. Up here in Iowa, it's down in Arkansas. It's that all day long. People don't have any trouble. It doesn't seem down there saying, I did this. I was wrong. I kind of want to promptly admit it, and let you know that I don't want to do that anymore, and I'm sorry. Will you forgive me? I don't think that's happened one time. I don't think it's happened one time. I don't think even Heather has. Well, a couple times she has. She's the only person. No one else has asked me for forgiveness of anything in Iowa since 2015. And that's just what is that? That's severe, is what that is. Severe. And that's what Iowa's judiciary is. Severe. So, all right, so I'll let you guys go, and I'll go back and watch this and see if I want to put post this one, because I just felt so uncomfortable at the beginning of this thing. Just gave me the creeps. But it's clear that there's no judge in control of this right now, because none of this would be happening. None of this would be happening. No attorney, Tiffany Meredith included, would have the chutzpah to just take the model rules of professional conduct, the rules of civil procedure, and professional misconduct rules, and just, she's brought a fraudulent claim that is not possible to be proved, and she hasn't withdrawn it yet. Maybe she knows that she doesn't have to. Maybe the protections has been called in. And I've caught myself in court in these situations before. It's happened to me before. I mean, why do you think they call it wrongful trial? Why do you think they call it wrongful conviction? Why do you think they call it wrongful imprisonment? Because that's what it is. And when you got 32 people standing in an adversarial relationship to you, afraid, scared to death that you're going to get out of the jurisdiction now or come back and sue them later, that's not a position you want to be in. And it's a position that's really hard to get out of. All right, well, thanks for listening to me, and some other time we'll talk.